Let's bring in the host of Nothing But the Truth podcast, criminal defense attorney Bob Bianchi. Bob, I want to play one more sound from the DA, Brooke Jenkins, in San Francisco, and we'll get your take on the other side. Watch.
We have the benefit of hindsight. Right now we understand that Banko Brown did not have a knife, did not have a weapon. But at that moment in time, it's about what the security guard perceived or believed. And was that reasonable?
And the security guard says that while they were on the floor and they were kind of wrestling on the floor together, that the suspect told him that he was going to stab him. So is that reasonable? What are your thoughts?
I can't believe this, to be honest with you, Trace. As a former prosecutor that evaluated many of these kinds of cases, this prosecutor, who's supposed to be a little bit more of a hardball prosecutor than the previous one, really blew it on this particular case. And her explanation of the law is very much lacking. Look at the facts of this case. There's a fight. Clearly, the security guard was winning that fight. If the security guard was concerned while they were fighting that he had a knife, then why did the security guard let him go, which he said he did voluntarily? Moreover, he has a shopping bag in his hand. His other hand is visible. That movement that you see where he moves his chest, really, not his body, towards him. When he points the gun, the security guard, he's moving away. The victim moves away and he fires. You just can't fire because you have a feeling, not a warm and fuzzy feeling, and you think that maybe it could be anything. The security guard even said, I didn't know what he was going to do.
Let me stop you there, Bob, because he did lunge at him, and that the video shows that. So what happens is the security guard says that he had the gun, he pulled the gun, and he was holding it at the floor, and he was waiting as the suspect was going out the door, and he said he was waiting to see if he lunged at him was something because he thought he had some kind of weapon he was going to use against him, and you can see he lunges forward. Now, he lunged forward to spit, not to stab him, but how do you know that at that very time?
He's got a bag in one hand and an empty other hand, and that lunge, respectfully, I believe is more of his body moving forward. But it's clear when the weapon is pulled out, he's moving away from the security guard. It's, by the way, the law isn't just that you feel that you were in reasonable likelihood of death or serious bodily injury. It has to not only be subjective, but also objective. A reasonable juror has to look at that and say, was it objectively reasonable to believe when the guy's got a shopping bag in his hand and his other hand is empty that he could cause serious bodily injury or death to the security guard? This was a bad shoot, plain and simple, and at least should have been presented to the grand jury and allow them to make the decision as to whether or not it was reasonable.
I got to go, but just let me so you think this was a bad shoot. What about in New York, the Daniel Penny case, the killing there of Jordan Neely? Was that self-defense? I've got 10 seconds.
Well, Trace, the apples and oranges are a completely different kind of case. The question in that case becomes, is it reasonable to keep somebody in a chokehold for many, many, many minutes when the person
it was
no
not 15 minutes.
moving?
Remember, it was less than 6 minutes.
I didn't say 15. I said many minutes.
Okay, just checking. So you think both of these things are not self-defense. Bob Bianchi?
No,
Go ahead,
Trace.
5 seconds. Okay.
Yeah, I think they're completely different cases to compare.
Got it. Bob, thank you so much. And